This series of webinars was developed and designed to give you a foundation to understand the business of music in the Caribbean. And I want to be clear, I'm going to refer primarily to the way things are done here in the Caribbean, which is different than the way things are done in other places. From time to time, I may refer to the business of music in other places like the US. And if you have questions about practices in different countries, please feel free to drop a question in the chat. And we're going to keep the chat open, after my formal presentation is done for about a half an hour. If folks have questions, ask away. We're delighted to have this opportunity to interact with you. It's fabulous that even in this time of COVID, I'm able to reach out to across the Caribbean and interact with practitioners from all over. So we are super happy to be here with you this evening. The learning objection for this session is to help you understand the basic features of copyright and distinguish between the two primary types of copyright in the music business. Those are the musical composition and the sound recording. To understand the business of music, we start with a basic understanding of copyright, which is the foundation on which the business of music is built. And so the goal for this session is to provide you with a basic understanding of what copyright is, why it's important, and to introduce you to these two primary types of copyrights that are used in the music industry. From there, we're going to go on in subsequent weeks to talk about different topics that build on this concept of copyright. But first, let's step back and look at the business of music from a legal perspective. When most of you think about the business of music, you think about transactions. You pay me to perform at a concert, or somebody pays me to download my song or stream it from Spotify or another streaming service. For some artists that are more successful, a company might pay them to endorse their brand or a certain product. But I'd like us to go a little bit deeper and think about why you get paid to do what you do. Why do people have to pay to listen to your music? The answer is that you, as a creative, you create intellectual property. You use your mind and your talent to create things in which you have exclusive rights. Tangible property is like a house. You design the house, you build the house, you can sell the house. It's a physical thing that you can touch, and you can protect it by physical boundaries like fences. But intellectual property is intangible property. You can't touch it. It's a lot harder to understand. It is your rights in your creations, such as copyrighted works or trademarks. But your rights can be sold or leased much like a house. So when we talk about the business of music, we are really talking about the transactions involving your intellectual property. Creation is the writing of a musical composition or the voicing of a master sound recording. The authors of the musical composition and the master sound recording have certain exclusive rights, and we'll discuss these later on. Transfer is giving those exclusive rights to someone else. You can do it for a fixed time, or you can do it forever. Acquisition is the process of getting those exclusive rights from other people. So at its core, the business of music is the creation, transfer, and acquisition of intellectual property. There are three kinds of intellectual property that are commonly used in the business of music. And those are copyrights, which we're going to discuss in depth today, trademarks, and image rights or the right of publicity. Copyright is what gives the owner of a work the right to reproduce it or copy it, to distribute it or to give it to somebody else, to perform or display the work publicly, and to modify or adapt it. Trademarks are symbols or signs that help a consumer identify the source of a good or a service. So in the context of the business of music, this might be your professional name, your artist name, or the name of your label, or even a catchphrase that is associated with you. For example, Zagazao right? Or woyoi are both catchphrases that are associated with certain artists. And if you know which artist I'm talking about, feel free to drop that in the chat too. The right of publicity is the right of a person in their name, their image, and their likeness. It's basically your right in yourself. Particularly for famous people, it gives people the right to control who can use your name, including your professional or your artist name, or your picture. This is particularly important to avoid an appearance of endorsement of events, brands, or products. And this is not a registered right. This is a natural right that is sometimes codified in law and sometimes in legal decisions. For the purposes of this training, though, we're going to focus on copyright. So what is copyright? Copyright is a collection of exclusive rights that is granted to the author of a creative work. And like I said before, those include the rights to reproduce or copy the work, to adapt it, distribute copies, publicly perform or publicly display, or to make the works available or perform them by digital audio transmission. And this last one applies only to sound recordings. Reproduction or copying is the act of copying. This could be digital copying, like when you press Control-V on your computer, or photocopying, like if you have a Xerox machine. Adaptation is the process of transforming a work from one medium to another. And that would be like if you author a book, if somebody wants to make it into a movie, that would be an adaptation of your copyrighted work. Another example of an adaptation is drawing a photograph, right? You have a photograph that you're copying, but you're transforming it. You're using your own skill and transforming it into a different medium. Distribution is the transferring of copies to other people. And whether that's physically, like handing it to them, or digitally, as we see more and more prevalent these days, by streaming or by downloading from iTunes or something like that. Public performance and display is the making of your creative work available to the public. And in the business of music, we often see this when, for example, a restaurant plays a song for its diners to enjoy. Or we see a lot in the Caribbean, public pay parties, where you have a promoter that has a party and they play recorded music. That would be a public performance of your copyrighted work. The making available right is a little bit more complicated, but it's a contemporary development in response to digital technology, which covers the right to make works available to the public, quote, in such a way that members of the public can access these works from a place and at a time individually chosen by them. And that refers to, in shorthand or in common speak, digital streaming services like Spotify or Apple Music. Performing a work by digital audio transmission is the US version of the making available right. And again, it covers webcasting and streaming. So you might be asking yourself, okay, I have this copyright. Well, how long does it last? The short answer is a very long time. In Barbados, the duration of copyright varies from country to country, and it can vary somewhat according to the type of work that you have. In the United States, it lasts for the lifetime of the author plus 70 years afterwards. Or in the case of a work made for hire, which we'll discuss a little bit later, it's a flat 95 years from the publication. In Barbados, Belize, Trinidad, and Tobago, copyright lasts for the lifetime of the author plus 50 years. St. Vincent is the lifetime of the author plus 75 years, while Jamaica is the lifetime of the author plus 95 years. The important thing to note here is that the exclusive rights afforded by copyright are going to way outlast you or me. And it's going to last for several generations after the author's death. So it's really important to consider plans to pass down your copyright to your heirs or establishing an entity or a company to hold your copyrights during your lifetime and after your death so that your heirs can benefit from your copyrighted works even after you pass. In the business of music, there are two essential copyrighted works: the musical composition and the sound recording. The musical composition is a song that can be played or performed by anyone. You could think of it like sheet music. I could play it, you could play it, some other popcorn could play it, right? The performance of a musical composition can be captured in a sound recording. And we typically refer to authors and composers of a musical composition, referring to the person who wrote the words and lyrics and the person who wrote the music. Sometimes we talk about splits or publishing, and this refers to the percentage of ownership of the musical composition divided between the authors and the composers. A sound recording is a recording of a specific performance of a musical composition. So here I have a very beautiful LP of The Harder They Come. The musical composition for The Harder They Come, the most famous version of The Harder They Come is sung by Jimmy Cliff. And that soundtrack, as you can see, you can see on the record, is owned by Island Music or Island Records. But a host of other performers have their own sound recordings of this musical composition, like Keith Richards, Willie Nelson, Jerry Garcia from the Grateful Dead, and Joe Jackson. Each sound recording is authored by the person who created it, and that's most often the producer of the sound recording. With sound recordings, sometimes we talk about royalties or points, and we'll talk more about these in another session. But you can think about these terms as dividing up the money received from a sound recording. So you have this copyright. You know that it lasts for a long time, but who owns the copyright? And the short answer is the author of the copyrighted work owns the copyright. This can be an individual or a company if the work was created by an employee or was created as a work for hire. Most times, if an employee creates a work in the scope of their employment, the employer is considered to be the author of that work. The author can also be statutorily defined, as in Jamaica, where the Copyright Act states that the author of a sound recording is the person by whom the arrangements necessary for the making of the recording are undertaken. And we see here an excerpt from the Jamaican Copyright Act. The highlighted portion says, author means the person who creates it. And in relation to a sound recording, it's the person by whom the arrangements necessary for the making of the recording or film are undertaken. So we typically understand that as the producer. But another answer for who owns the copyright is an assignee. If the work is assigned to another person or company by the original author, then that person is considered to be the owner of the work. Registration of copyright is a formality that provides you with certain advantages. You own the copyright to your work as soon as it is finalized, but the registration of the copyright with the appropriate local authorities is encouraged, as it can provide proof of authorship, ownership, and the date of creation. And in certain jurisdictions, it is only once you have a registered copyright that you're able to bring suit for copyright infringement. And that's the case in the United States. Copyright registration is not required, but it is strongly encouraged. You can register your work in your home jurisdiction or in another. The Berne Convention is an international treaty which ensures that other countries will treat your copyrighted work with the same respect as they treat works owned by people from that other country. Are you able to make the presentation full screen?
It is full screen.
Okay. Can we turn off the video for the other presenters? Go to the, like Melissa or Siobhan. Okay, people in the chat, are you able to see the presentation better now? I'm going to carry on in the meantime. Okay, awesome. I see, yes. Okay. Now I've lost my, I don't know where my mouse is gone. Hi. All right, so the Berne Convention is an international treaty which ensures that other countries will treat your copyrighted work with the same respect that they treat works owned by people from that other country. So even if you register your work in, for example, Belize, assuming that Belize is a party to the Berne Convention, and most countries are, with the exception of, I think it's Iran and maybe Eritrea or something very esoteric. Other countries will have promised by this convention to give your copyrighted work the same respect that they would give to copyrighted works from their own jurisdiction. The way that we show that a copyrighted work is copyrighted is by using this C in a circle, which you see now. And typically it's presented as copyright with a year and your name. And the purpose of this is to provide everybody with notice that your work is copyrighted, it's owned by you. So they mustn't copy it, they mustn't misuse it, etc. For more information on how to register your copyright, I have a series of links here, and the presentation will be available on the ACCS website for you to look at your leisure, and you can look at the various IP offices in the various jurisdictions to have more information about how to register your copyright. All right, so we now have an opportunity for some questions, but first, I want to walk through some hypotheticals based on the presentation to see if you guys have really understood what we are talking about. Okay. So scenario one. The Guys is a quartet that started playing together in fifth form in St. Aloysius College. They're signed to Mango Records. They record a cover of The Harder They Come. Who owns the musical composition and who owns the sound recording? And Andre, if you go down to the bottom of the webinar screen, you see polling. See if you can access a poll. Yeah, so let's launch the poll. All right, so we're launching a poll. You guys respond and tell me who it is you think owns the musical composition, right? The Guys is recording a cover of The Harder They Come. And who owns the sound recording? So remember, this is the musical composition, right? And this is the sound recording. Anyone want to take a guess at who owns what? Can you move the poll to the top right of my window? Yeah, perfect. All right, who owns the musical composition? I have a couple of responses. Jimmy Cliff. 4 brave souls are responding Jimmy Cliff. Spoiler alert, that is completely correct. Kudos to you. Good job. All right, so who now owns the sound recording that was performed by the Guys? Scroll down for me a little. Perfect. Mango Records. I have 8 brave souls. You guys are completely correct. The Guys is signed to Mango Records, so the sound recording that they produce would be owned by their record label. All right, let's throw a little wrinkle in the works, right? You record a cover of The Harder They Come in your home studio. You are not signed to a label. Who owns the musical composition? For those of you, 2021 folks that are responding Jimmy Cliff, absolutely right. Jimmy Cliff owns the musical composition for The Harder They Come, no matter who performs it. No matter whether it's you, no matter whether it's the Guys, no matter whether it's a Keith Richards, if it's me, anybody that performs that musical composition, Jimmy Cliff owns the musical composition. Who owns the sound recording if you record a cover of The Harder They Come in your home studio, you're not signed to a label? Who owns the sound recording? And I see 27 people, 29 people with the right answer. You own the sound recording because you recorded it, you made the arrangements, you set up in your home studio, you pressed record, that baby is yours. Great job, guys. Congrats. Cool. All right, so let's move on now. These are some harder scenarios that don't have definite answers. So I'm looking to the chat for you guys to give me some feedback here. Scenario 2 is Roy Dell is a young producer. He builds a rhythm and he asks his friend Dwayne to come and voice. Dwayne writes his lyrics. His friend Clarence drives him to meet Roy Dell at the studio, and Dwayne voices over the rhythm. Who owns the musical composition and who owns the sound recording? All right, Andrew Castillo, I see you saying Roy Dell. What does Roy Dell own? All right, Darcel says that Dwayne owns the composition. That is partly right. Andrew Castillo says that Dwayne owns the musical composition. All right, Jamila Falak. Hi, Jamila. I'm a big fan. Thanks for tuning in. Jamila's got the right answer. Roy Dell and Dwayne own the musical composition because they wrote it together. Roy Dell built the rhythm. Dwayne wrote the lyrics. Together, those come together to make the musical composition. Next question. Who owns the sound recording? And I see Keon DeLas, James Sanker, Warren Fort. Let's say the right answer. Jordan Chong says Clarence have to get him gas money, and that is totally true. If you ask Clarence to drive you over there, you better give him a gas money. Gawain Clark, Andrew Castillo, awesome. Yes. Roy Dell made the arrangements, got the studio time, asked Dwayne to come over, voiced him, Roydell would be the owner of the sound recording. So great job. All right, here's a twist. As Dwayne is voicing in the booth, Clarence, remember Clarence? Clarence gets a gas money. Clarence might get more than gas money. Clarence turns to Roydell and suggests that Dwayne change the hook. Roydell agrees and tells Dwayne. Dwayne voices the hook with the changes, and everyone agrees that the changes are good. What are the splits? Right? So we're looking, this is the case, we're looking at the musical composition. We had said that Dwayne and Roydell had the musical composition, but here comes Clarence. Does Clarence get a share of the musical composition? So Cliff Kennedy says Rhythm Maker owns 50%. And I will say that that is the custom in the Caribbean. The person that builds the rhythm is typically the owner of 50% of the musical composition, but that's not a hard and fast rule. You have to have some flexibility for scenarios like this. Gail Callender says it would depend on their arrangement. Totally right. Steve Golding says Clarence now gets a share. I think that's right. If Clarence suggests a change to the hook, and most people will tell you that the hook is really the heart of a song, I think there's a pretty good argument that Clarence gets a piece. Darcel Grant says an agreement is needed. Totally with you, Darcel. Totally with you. And this is why, as a practitioner in the industry, I encourage all of my clients to have a split sheet, to have a production sheet, to make a record of what the splits are. Because too often I see my clients get to the point where they have not agreed anything. And all of a sudden the song is a smash. And then everybody is fighting over who gets what piece, right? Poor Clarence could be left out in the cold. Clarence needs to speak up and tell everybody that he wants a 5% for his contribution to the song. And that's totally off the top of my head. I don't know what Clarence really added. It could be more, it could be less. Juanita Clark says Clarence should get a split, but only if agreed on. Totally right. Dwayne McDonald says to give Dwayne all the publishing. Dwayne, I'm with you, but you gotta share. And Darcel points out that yes, before he leaves the studio. And this is the hardest part, honestly, in this business is, it's the thing that I hear from my clients over and over again. Nobody wants to brook the vibes, right? You're in the studio, you're recording, you're writing, you're having a good time, you're vibing, everything is going great. Nobody wants to be the person that at the end of the day whips out the sheet of paper and the pen and says, here, sign this, right? Because then everybody is, you know, why you want me to sign something? But honestly, it's really best if these things are discussed in the studio at the time and put down for posterity. Micah Jeffries, split sheets are needed. Totally right. All right, moving on. Scenario 3, this is another one I see a lot, right? Mark is a producer. He's not really a musician, but he has an engineer, Gary, who he pays to build rhythms for him to voice artists. He usually tells Gary to make some changes to the rhythms before they're ready for voicing. Mark books studio time and invites a well-known artist, Shanique, to come and voice on his rhythm. Shanique brings her writing partner, Tasha. Tasha writes most of the lyrics and Shanique voices on the rhythm. As Shanique voices, she ad-libs some of the lyrics and then adds her signature catchphrase to the song. You know what the questions are going to be. Who owns the musical composition and in what shares? And who owns the sound recording? Let's take them in turn. What do people think about the musical composition? All right, Kian Delas says, Mark, Shanique, and Tasha own the musical composition. Mark, Tasha, and Shanique, says Cliff Kennedy. Cecil Joseph says Mark alone, but but Cecil, what about Tasha and Shanique? Do they not get a share of the musical composition? Remember, the musical composition is, if we look at it, right? I don't know if you can see it. Words and music together, right? Ronaldo says Mark and Shanique. Cecil says he gets a piece, and that's right. That's right. And the key here, poor Gary, but what I'm trying to get at here is this idea that Mark has an arrangement with Gary that is similar to what we would call a work for hire arrangement. Now, let's be clear. Mark and Gary really ought to have some paperwork, right, that captures their agreement, in which Gary acknowledges that what he did is for Mark's benefit, because he's getting paid to write the rhythms. Without an agreement like that, Gary would have a pretty strong argument that he is entitled to a piece of the publishing and that he's entitled to more of the publishing than Mark. Alfonso says Tasha, Shanique, and Mark own the musical composition. Mark owns the sound recording as Gary's work for hire. So Alfonso, I'm totally with you. That's the second question, who owns the sound recording? I think this scenario supports that, right? He booked the studio time. He invited the artist to come. He arranged for the engineer to be there. I think it's pretty clear that Mark would be the owner of the sound recording. Ronaldo says Shanique and Tasha has a separate agreement, and that may be, right? If Shanique and Tasha work together a lot, and I see this a lot too, Shanique and Tasha may have an agreement between themselves that Tasha gives Shanique a piece or a greater piece of the publishing because Shanique is a well-known artist and because she is, you know, bringing more attention to the song than Tasha would otherwise get. Gawain Clark says the shares are based on agreement. And that's the other important thing, right? As you see, as these scenarios are more and more complicated, really and truly, the best thing is to have these discussions, to have these, you know, these issues hashed out, maybe put to paper, hopefully signed, so that down the road, when it comes time to release the song and when it comes time to register the splits with your CMO and with your publisher, that all of these things are clear and you're not getting into conflict down the line. Steve Golding is asking that, are we clear that musical composition is music and lyrics? And I hope that is clear. And again, I'm going to point to this sheet music, right? This idea that the musical composition is both. It's the coming together of the music and the lyrics. And I guess maybe I can hold this closer so that you can see that there's both words and music on here. It's not just the melody alone. It's not just the lyrics alone. All right. Any more questions on this before we move on? And Dwayne from Bubble Rock can tell you that I am constantly chasing them for splits. And Dwayne from Bubble Rock can probably tell you that it's a good idea to have the splits worked out as early as possible so that people like me aren't chasing you down for months on months to try and get the splits so that we can register them. Right, Dwayne? Right. All right, here's another scenario. Scenario 4. Rory is an established producer. He's working on an album for a promising new producer called Jaw Turks. He calls up his friends Rowan, Dean, Mike, and Ian to come in and play the instruments for the songs on the album. Rory has written most of the songs, and the musicians play the songs as written by Rory with a few embellishments. At the end of the sessions, Rory doesn't have any money to pay the guys. He promises them publishing shares instead. Who owns the musical composition and in what shares? Anyone want to take a stab at this one? Gawain says all of them own a piece. And I think that's right. If Rory has promised all of his musicians a piece of the publishing, then Rory should give all of the musicians a piece of the publishing. And it's up to them to agree. Juanita says everyone. Kenroy says Rory owns the most, and that's true. You know, the musicians on the songs played a few embellishments. There's publishing that they're entitled to for those embellishments. But my point is that Rory should probably amplify what the guys get because he hasn't paid them any money. Jordan says, tell Rory for away with that. I'd advise anyone who gets promises of publishing to sign a written agreement. Totally sound advice. But in this case, I'd say that Rory's been working with these guys for a long time. So there's probably a really good measure of trust between them. Sharad says, question, wouldn't he own the musical composition entirely? And the point is this, right? That publishing splits can be whatever you want them to be, right? There is a natural order in which they fall. There's a custom, you know, especially in dancehall and soca, we see that the producer, the builder usually gets 50%. If the artist writes his lyrics or her lyrics, they get a 50%, right? But there's all kinds of permutations. And what I'm hoping to show you guys with these scenarios is that it's never quite that easy. There's always somebody that adds a line to the hook or suggests a change or maybe says, play this, don't play that. And those people are also eligible for publishing, but it has to be agreed. And the earlier that it's sorted out, the better off you are. Kenroy says split sheets are needed. Totally right. Nothing is cast in stone. The rules vary. Fluid as the vibrations of sound. I love that lyrical take on it, Darcel. Daryl, I want to hear more from you. When you say some of the information regarding the ownership of the musical composition, the first case scenario is incorrect. Why do you think it's incorrect? And shoot me a message in the chat. In the meantime, we're going to move on. This last slide is something that we've not really spoken about, but I'm curious to see what you guys would do with it, right? Ian comes to you for advice. He's a lifelong session musician and backing band musician, and he wants to buy a house. He has credits on countless songs over the years, and based on his credits, you think he ought to be able to get a decent publishing deal with an advance to help him with the down payment. You ask Ian for his catalog, and he reels off a list of songs. What are his shares, you ask? He doesn't know. How can you find out what his shares are? Any ideas? Darcel suggests contact his PRO. That's an awesome suggestion, right? And that would be probably my first look, would be to search, if possible, with his PRO or CMO to find out what catalog they have on file for him, right? But Ian being Ian, right, he might be relying on other people's registrations of his works, and those might not be entirely accurate. So that might be a great first step, but you might still have to discuss it with Ian. Juanita says go to CostCap or whichever is his copyright company. That's the same thing. Cecil's suggesting Echo. These are all PROs, and these are all totally great suggestions. Shaquille says ask his manager. I love that suggestion too, but more often than not, the manager will be just as clueless, unless you're Dwayne, because Dwayne, he's on top of these things. Research the songs, get a lawyer. I love these suggestions, and I think that they're right. But the point here, the overall point is, It's really difficult, especially when you have credits on countless songs over the years, right? And it might be 10, 20 years that we're talking about. It's very hard to go back and reconstruct what all of those shares are. So if you're a musician, if you're a session musician, if you're a backing band instrumentalist, you're getting credits on songs, you're playing in the studio, part of the reason why split sheets are so important are so that you have a record of what copyright interest you have. Because when it comes time to monetize that copyright interest, you have to know what you have before you can tell somebody else what it is that you can use it as security for, or how you can monetize it. All right, so Alfonso has responded from the previous question. Would the individual musicians themselves have to be associated with their own publishing companies, or can they go through Rory and rely on him for the splits, or would it go directly from them to his publisher? That's a complicated question, right? I would say that more often than not, what we see is, in that kind of scenario, that one person, and it's usually the producer, will register the splits with the publisher, with their own publisher, right? And those splits get transmitted to the various PROs and so forth. So the PROs might have a record of Ian's share, for example, even though Ian didn't register that share with his own CMO. The challenge with that is, I cannot tell you the number of times, right, that I get split sheets, or I ask a client for splits and they say, oh, Ian, I don't know Ian's last name, right? Or they might misspell Ian's last name. They might not include Ian's IPI or CAE number. They might not include Ian's PRO. And with every piece of missing information, it makes it harder and harder for Ian to collect his share, because they might have him as EION instead of IAN, right? And then, computers are dumb. They see that and they think, well, that's two different people, right? So Ian might not be getting credit for all of his works, and it might not be malice. It might just be mistake. So it's really important for everybody to be diligent about registering their own splits so that they can ensure that all these little mistakes are not made. All right, any other, that's really the end of what I had prepared for today. But I want to leave the chat open because I want to continue. I love these questions and I want to keep discussing them. First, I want to thank you for your attention and for participating. I want to thank Compete Caribbean and the IDB as the gracious sponsors, and ACCS as well. These are the folks that are making this webinar series possible. I also want to mention that we're going to be here again next Tuesday, same time, same place, and we'd love for you to tune in and talk about, next week, I think we're going to talk about music licensing, which is a really critical piece of the puzzle when you're talking about the business of music. So I hope that you've enjoyed this. I hope that you'll be back with us next week. And let's keep going with some questions in the chat, unless Lisa or Melissa want to say anything in closing. Maybe just drop a note to me and we can break away. All right, let's see. I think this is good. Let's start with TT. TT says, if an artist buys a rhythm from you, are you still entitled to royalties? And that is a question, it's a great question, because it is a scenario that we're seeing more and more. I'm seeing more and more of what we call beat leasing or beat, ghostwriting. Rhythm makers are making beats and then just giving them or selling them to artists. And the answer is that it really depends on your deal, right? I hope that most of the time if you sell a rhythm or lease a beat, that you negotiate hard and you still get your publishing percentage, right? It's not unusual for the beat maker to receive a royalty on the master sound recording as well, right? But that royalty is going to be pretty small. The standard practice in the US for major label deals is that a producer, right? And remember that the producer is the original owner of the sound recording, right? So if a producer is producing a song for an artist that's signed to Interscope, they have to actually complete paperwork that assigns the sound recording over to the label. And in exchange for that, the typical producer royalty is in the range of 3 to 6%, right? So if you're a beat maker and you're selling a beat to a producer to use with an artist, your royalty rate is going to be somewhere south of that. It's probably going to be maybe 1 or 2%. 1 or 2% does not sound like very much, but if you're producing for a big time artist, those little pieces of royalties can amount to pretty reasonable checks. So don't sleep on that aspect. And thanks for that question, TT. Mark says, in a scenario where a beat is made and multiple people write and sing on it, who owns the composition? So that would be like one of our earlier scenarios, maybe scenario 2 or 2A, right? And typically the publishing would be shared between those various people, right? Remember here, we've got Dwayne voicing in the booth. Clarence suggests a little change to the hook. Roydell has built the rhythm. And so I would argue that all 3 of those guys are entitled to a share of the publishing. All right, Jamila Falak. Can more than one person own the sound recording? This is a question I run into all the time. Technically, the answer is yes, but practically, I really don't like, in my practical legal work, I don't like for more than one person to own the sound recording. Why? And we're going to really get into the why in our next session when we talk about licensing, right? Licensing is, apart from, licensing to a distributor, but when we get into sync licensing or master use licensing, and those would be the kinds of uses where you're licensing the master sound recording and the musical composition for use with like television commercials or in movies, right? Those deals move like this. And if you have to be hunting down the other owner of the sound recording to get their sign off and to get their permission, and this is purely a practical consideration, it can really jam up the works. And those deals are moving so fast that, if you can't find the person for a week, if they're on tour in Europe and you can't, WhatsApp not working or their data not working and you can't get a hold of them, you could lose the opportunity simply because that person is not available, right? Now, that said, right, it's still possible for one person to own the master sound recording, but to share royalties evenly with somebody else, right? So you could have a situation in which one person owns the master sound recording, but they pay a 50% royalty to another person. And that might arise, you might see that scenario in, where a producer voices an artist and the artist says, yo, I want 50% of the royalties. It's like a revenue share kind of deal. And they could agree on that. But you can't assume that that's the case. And remember that in copyright law, the person that makes the arrangements for the sound recording in Jamaican law is considered to be the author and the owner of that sound recording. That's the default. So unless you agree in advance with the person that made the arrangements for the sound recording, then you are you're disadvantaged in your argument that you're entitled to a certain amount of royalties. And I will say that it's a ever evolving practice. I love to see my clients, you know, sharing the wealth, sharing the revenues. Although a lot of producers will argue that it costs them a lot of money to produce the song, to mix it, to master it, to do the artwork, to shoot a video. And these are all costs that they want to recoup before the revenues get shared. And that's not, you know, that's not an unfair argument. Let's see, what other questions do we have? With regards to registering, if you and someone else own a studio and both of you collaborate in each rhythm song, should both persons register individually as a publisher, or can you register in the name of your company? That's a bit of a complicated scenario, and I would probably need more details to like give a real solid opinion there. But what I do want to point out, Juanita, oh, there's Q&A. Oh, awesome. Okay. What I do want to point out is we need to remember that a publisher is a completely separate entity, right? You as an author, you as a composer, you have the ability to register directly with your CMO, right? Or your PRO. And those are like JCAP, BSCAP, COSCAP, COT, ECHO, right? But a lot of people sign publishing deals with publishers. And publishers are companies that specialize in collecting publishing royalties, right? Or royalties coming from the master of musical composition from around the world. These could be mechanical royalties, which are statutory royalties, basically automatic legal royalties that are paid or supposed to be paid every time a composition is played. And a lot of foreign countries have you know, agencies that collect these on behalf of writers, authors, composers. And it's a lot of work to go and try and track down each of those entities by yourself, right? We all know that music from the Caribbean is a worldwide phenomenon. It's played everywhere. It is a huge cultural export, right? So if you were, I think it was Juanita, if you were to try and go and track down all of these different agencies to pay you the royalties that they owed you, you would have a very, like a full-time job, right? Which is why, you know, a lot of people use publishers to maximize the revenues that they can get from their musical compositions. All right, do copyright laws that apply in the Caribbean also apply in Latin America? Each country will have their own copyright laws. But most countries, and when I say most countries, it's something like 180 plus countries in the world are signatories to this thing called the Berne Convention, right? And the Berne Convention says that each country has to give a copyrighted work from another country the same respect that they would give to a copyrighted work in their own country, right? So that doesn't necessarily mean, for example, that Brazil would recognize certain Jamaican laws regarding copyright. But if you have a Jamaican work for which the copyright is infringed in Brazil, they have to treat it with the same respect that they would accord a Brazilian work that was infringed. And so this is it's a very important concept, because again, if you were to try and register the copyright in your work in 180 something countries in the world, you know, it is an extremely expensive and tedious process, right? This is a nice way, it's a shortcut, basically, to say that your work is protected pretty much, you know, anywhere we would go. Okay, so I have a question in the Q&A, and I apologize that I wasn't watching the Q&A earlier. I think this is a very good question, and it does get into some of the nuances of copyright, right? If a musician does an adaptation of a song, he now owns the sound recording of the adaptation. However, does the adaptation infringe on the original composer's copyright in any way? And the answer is absolutely yes. If you remember that one of the exclusive rights in copyright is to adapt the work, right? So if you look at the song, there's a recent song by Conqueror and Shaggy, right, that has a riff. It's not a sample because they play it over, but it contains a riff from a Harry Belafonte song, which was not written by Harry Belafonte, and the names of the composers are escaping me at the moment, right? In order to clear that song, in order to release that song, their teams had to go and get permission from the publishers of the original copyrighted work to make an adaptation, right? And the publishers typically, and I don't know the details in this particular case, but the publishers will typically demand a piece of the publishing in the new song, as well as a fee. And then a percentage of, often they'll demand a percentage of I've lost the feed, royalties as well, right? And that can get, it can get very expensive. In certain cases, there was a case with the, there was it wasn't a Major Lazer song, but it was one of the very first viral songs. I think it was Harlem Shake or something like that. There were 2 samples that had to be cleared on it, and both of those publishers claimed an enormous, you know, piece of the writing, of the publishing shares in that song. So copyright is always about, you know, standing on the shoulders of giants to create new works. Just be aware that the giants may demand their pound of flesh when it comes time to get permission to use their work in a new way. All right. All right, so Ethan from Barbados, so just to confirm, based on the Berne Convention, am I correct in understanding that a copyright or trademark registered in the Caribbean will be equally protected in other regions such as America? Yes to copyright, no to trademark. Trademarks are strictly territorial things. They're valid only in the country in which they are registered. There is no similar convention for trademarks like the Berne Convention. It's exclusive to copyright. So trademark, you have to register country by country. A copyright, you're afforded the protection in other countries just based on your ownership of the copyright in a country that's a member state of the Berne Convention. Okay, anonymous and attendee is asking, if your song blows up off of a lease beat, what are the first steps the artist should take, especially if the beat contains a sample? Whew. The first step you should take is buckle in, because it's going to be a hell of a ride. A lot of it depends on the terms of the lease, of the agreement with the beat maker. That's part of it. If the beat contains a sample, hopefully your lease agreement says that the beat maker has gotten, you know, they rep and warrant, or they promise to you that they've cleared the sample. The sample's not cleared, but the song is blowing up. Guess who's going to have to clear that sample? You. And that could be expensive and tedious and stressful. But all of these things are going to be on a case-by-case basis. So it's a difficult question to answer, but I think the short answer is it's going to be complicated. All right, Lonzel is asking, if a producer produces a track for an artist, she paid for production services, no split sheets were signed, does the producer have any rights to that track even though splits were not signed? That is a tricky situation. Without paperwork, remember that the default is that the producer is going to own the master recording. So you really need to get that paperwork in place. You really need to, you know, have a discussion with the producer, clarify. You know, a lot of producers understand the business and they are on board with paperwork. A lot of producers are not. So it really depends on who you're working with. But I would try and get that sorted out, you know, as soon as you can. All right, Shaquille is asking, if I pay musicians to lay down music on a track I voiced and wrote at 2 different studios and paid someone to do the mix and mastering, how are the royalties split? Shaquille, that's a very complicated scenario. The short answer is they're split however you want them to be split, right? And it's going to boil down to whatever business terms that you strike with the musicians. The mixing and mastering, I will say this, right? People that mix and master, engineers that mix and master, are typically not entitled to royalties. They're typically paid on a per song basis, on a flat fee basis, and they don't usually take any royalties, at least not in the deal structures I've seen. The musicians, if you paid them, again, their contributions are more than likely works made for hire, but you really should get this sorted out between you and them, hopefully with paperwork, hopefully signed. Andre, are you giving me the wrap it up signal? Yes, okay. Yeah, all right. Let's see. I had seen a question from Steve Golding in the chat that I wanted to go back to, which was the question about, and I'm sorry, I just glimpsed it. Okay, is the term executive producer obsolete? That's a tricky one. I don't think it's completely obsolete, but I think it's a structure that we're seeing less and less, or at least in my practice, I see it less and less. Executive producer in the past has often referred to really the kind of money man, the person that's putting everything together and that's, you know, doing the A&R and things like that. Much of the work that I see these days is really artists, is DIY, is producers working with artists directly. I guess, you know, in a project like, I have a client that produced an album with, you know, 17 or 18 tracks with different artists. I guess in that case, you know, you could really look at that role as executive producer. But it's a credit that we don't see as often in the Caribbean. You would see it more in the major label context in the US. Trying to see. Oh, keep going down, I think. Oh, sorry. In the Q&A, I see a question about the industry standard or industry average for royalty distribution percentages for all parties involved. And that is a question that, again, varies a lot by context. In the major label scenario, once upon a time, it was like 8 to 15% royalties that you were seeing. Now it's really more in the like 15 to 22% for a recording artist signed to an exclusive recording agreement, and that would be with a major label again, or a sub label in the major label context. But if you're a producer, you're working with an artist, you know, you didn't pay them to show up at the studio, you might consider giving them more. You might consider giving them less. It really depends on your practice, on your relationship with the artist, and factors like that. So it's a little bit hard to say, but there are, and it can vary as much as you want it to. Like Jamila was saying, it can you can have a 50% revenue share if you want. But most often in the major label context, I'm seeing, you know, 15 to 22%. All right, if a producer, oh no, we did that one already. Oh, Marie, what is the status of moral rights in the States? Not good. The US does not like moral rights. And what moral rights are basically the right of an author to have their name associated with the project, to object to certain, you know, derogatory treatment of it, and so forth. The United States moral rights is a very, very weak area of law. It's much stronger in other countries, particularly in Europe. It's much stronger. Nali Matthias is asking if I'm signed up to copyright.gov in the United States, does that work to my advantage or disadvantage living in the Caribbean? Neither nor. The one nice thing about registering your copyrighted work in the US is that many times the infringement that happens in the US is by people who have much deeper pockets, shall we say, than people living and working in other places. And the United States has this concept of statutory damages, which I'm not going to go into in detail, but it's basically a theory of damages that says you don't have to prove your profits from the infringement. You can let the judge decide the amount that the infringer should be penalized for infringing your work. And statutory damages are only available if you have a US registered copyright. So I would say that there's actually some advantages to registering your copyright in the United States. There's nothing to say that you can't register the copyright in other places as well, but it's more expensive. It's $65 per work in the US. In Jamaica, most recently, the fee is somewhere around, I think, $2,200 per work, Jamaican, which is today maybe like $17, $18 US. So it's a pretty significant cost savings to do it locally. But if you think that there's a chance, so for example, I have some clients that have pitched songs to a very well-known artist of Caribbean origin who has been threatening to put out an album for many years, as have, I'm sure, many of you and many other people. But in that case, where they're sending a demo over to be considered by this like really popular artist, my recommendation is, look, register it in the US. Because if it is down the line that your work is infringed, if they use a piece of it, if they sample it, or if they borrow you know, a melody or a refrain or something like that, you want to be able to go to court in the States to demand your pound of flesh. And so in that, you know, in that specific case, I think there's a clear advantage for registering in the US, but there's lots of reasons why you would want to register through your local copyright agency as well. Dwayne is asking, does the 3 to 6% sales royalty for producers apply for independent labels as well? Short answer is it depends what independent label you're working with. If you're talking about an indie that's signed to a major, then yes, that's pretty standard. So for example, if it's like a Mad Decent or a Rich Immigrants or something like that, the 3 to 6%, or what was 3 to 6% is pretty standard. But if it's a truly independent, self-release, then that's totally negotiable. And the producer might say, look, you know, I need to recoup my money first, or you need to give me a recording budget so that I come out equal, and then the royalty is paid on top of that. One thing to be careful with in that context, and I'm just going to mention it here, is that many times these producer agreements will involve an advance that is recoupable before you see any royalty payments, right? And that is intended to get the producer a little bit of cash in pocket, and the royalty streams come down the line. The challenge with that is that you want to make sure that the recoupable costs are for your song only and not against the project as a whole. Because I've seen situations where a client has signed a producer agreement with a label. They gave us a very small advance, and the song blew up and became the artist's biggest hit in the last decade. But the label, the agreement that he signed, and I want to be clear that I wasn't representing him at the time, but the agreement that he signed had his advance recouping against the project as a whole. And it said that he couldn't, you know, get paid his producer royalty until the entire album had recouped. And that song was released probably 7 years ago, and the album still hasn't recouped. So you need to be careful. These are the minutiae, the details that entertainment lawyers are really important to consult, because they will come back to bite you in the end. All right, TT is asking, will I be able to replay this after the stream is over? The answer happily is yes. We are recording this. It will be available, I believe, on the ACCS website, and I will confirm that. And so yes, you will be able to replay it. All right, Darcel, how do you go about rectifying an in the US if you are based outside of the US? The short answer is you need to get a good lawyer. You need to get a good lawyer in the US. And that in and of itself is a challenge, because US lawyers are expensive. And in many jurisdictions outside the US, there's this concept of fee shifting, where the loser pays the costs, legal costs of the winner. The US doesn't have that rule. So you're going to have to find a pretty flexible lawyer, somebody that's going to take the case on contingency, probably somebody that sees the value of the case to help you with your claim. And Darcel, are there legal pro bono clinics, or will a lawyer take your case based on merit if this is legal? Yes, a lawyer can take your case based on what we call a contingency basis, and that basically says that they take a percentage of anything that you recover. Typically, the percentage is higher because there's risk involved. So it might be, you know, 30, 35, even up to 50% of what you recover if they do it on a contingency basis. At present, I'm not aware of any legal pro bono clinics for entertainment law. I think that that is definitely a need that the industry needs to address. Throwing it out there to Dwayne and to Jordan and to other folks on the chat that I know are involved with industry associations to make that happen. I'm happy to help. I say that, but there are entertainment lawyers around. And I think it is really important to get some kind of a pro bono initiative to help folks that otherwise wouldn't have access. But Remember, you guys also have another 3 webinars that you can tune into next Tuesday, the 15th, the 22nd, and the 29th. We'll be talking about other areas of the music business, licensing, revenue streams, all of these topics that are so important for you. I'll be here to answer your questions. But now it's 6:30, and so I'm going to have to wrap up. I very much appreciate your attention. I really appreciate you tuning in, and I hope to see you next week. Thank you very much.